legislation. And I think you can even detect that goodwill on the part of those drafting the 2014 amendments to the Labour Relations Act, in that there is, I think, within the legal establishment, still a determination to try to do the right thing by essential services and to ensure that there are adequate compensatory guarantees. I don't think it's that there's so much a lack of goodwill. And the labour movement that combined South African trade unions, COSATU, was seen very much as an agent of change, you know, the transition from apartheid to a free South Africa. And that goes back to what Adriana was saying about the Italian constitution, this idea of the right to strike as voice, you know, political voice. So there's all of this, and yet at the same time, despite all this goodwill, there's growing disenchantment with the workings of the labour market. So South Africa never negotiated for itself the effective positive discrimination measures that it probably needed to address forms of the legacy of apartheid. There are still, although the racial mix of the middle class has changed, there's still considerable isolation of the vast mass of people who, as they were saying in the video, don't have regular access to water, electricity, and who experience these things being cut off for fairly, and education, and experience these things being cut off because they can't pay, or simply because there's, you know, a problem with distribution. So they don't see themselves necessarily getting the benefit of essential services. They're not fully invested as citizens and workers. And that creates this huge disjuncture between a very optimistically constructed legal system around labour standards and the reality of what it is to work within South Africa for the majority of people. And I think that's what comes through so strongly in the paper, is that disjuncture the whole time. There are many echoes from elsewhere. So the idea of requirements for protected strikes, the conciliation requirement is very similar to this genuine attempt to reach agreement within Australia as a precondition for protected industrial action. And that you have to give 48 hours notice or 7 days notice when the state is the employer. So protected action really matters, and it matters in a way similar to the Australian and the UK context, where the employer can't dismiss you for taking part in a protected action, which is better than the UK protection, by the way. And also there's protection of the union from a claim in tort, which makes a difference.
Only if it's protected strike.
Right? Only if it's a protected strike, yeah. So the difficulties around essential services, and as I said before, Section 213 of the Labour Relations Act defines essential services in line with ILO standards. And the idea is that there is an essential services committee, which is perhaps more specialised than the Fair Work Commission, which designates what are essential services and then also ratifies or determines minimum service levels, and then decides what compensatory measures can be taken. There's been clarification of this process so that it is clear that where you have a minimum service, that can still be regarded as such a constraint on your ability to take industrial action that you're also entitled to arbitration. But it's not necessarily taken up by the workers concerned. Arbitration awards are binding on the state, subject to tabling in Parliament and approval. So you can't have these arbitration awards necessarily being binding per se. They have to then go through a parliamentary process, and that's still the same. So it's a fairly complex system. And what comes through in the paper and in the presentation is this problem of a lack of fit between the legislation and the reality of how everything is organised. So there is a problem with the public sector bargaining councils, as was said before. So you have the local government bargaining council covering 257 local councils, which deal with an entire mass of workers engaged in very different forms of activities, some of which are essential services, some of which aren't. And it reminded me a little bit of what Roberto was saying in Brazil and what Nikita was saying about Russia, where you have dominant majority unions, which comes out of the CASADA framework. There is a difficulty in South Africa in getting the voice of minority unions heard within this process. So you could do that by fracturing the bargaining units, but then you lose forms of solidarity and the power that South African trade unions have traditionally been able to wield. On the other hand, if you get the minority unions, then at least you might get some kind of access to voice and legitimacy. And I think, for me, it's just interesting because it does go back to what Adriana was saying before, that without the right to strike connecting to people's genuine desires and voices, you can have all the legal architecture you like, but it won't necessarily work. So there are some very interesting concrete suggestions in the paper which would improve things. So making sure the panel of arbitrators are familiar with public sector and essential services issues. But that does look like a little bit of a band-aid on a bigger problem. And I would be really interested in hearing from someone like Roberto about what you make of this situation and whether you see comparisons and whether you see solutions here.
Well, we have very similar situations. When we did a paper for the collection comparative labor law that we compared the BRICS, South Africa was more similar to Brazil than China and India and Russia. It's a very strong informal labor force that in our case, with one just union that represents everybody, there's no competition, there's no way of getting a voice to express, things, how things can be changed. So it's very similar.
I wish they would be here, but you know that they didn't come here because of the boycott. You should know. There is a reason why they are not here. South Africa has a boycott and includes academic activity on Israel, and I think it's fair to say that it should be kept confidential. I have several questions. Maybe they should answer them, but I didn't understand exactly. First of all, whether for a law in action, whether the idea that the parliament has to approve an arbitration award, how many times in the past arbitration award was not approved? If there is any problem, maybe it's just ceremonial and it's not a problem. Second, I really didn't understand how arbitration is invoked and in which situations, and what are the problems that they have experienced with the arbitration. This is the second question. Third, I didn't understand how the minimum, now I hope I understood now that the parties have to agree on minimum service, and if not, then this Council of Essential Services makes the determination and it's binding, and whether there is judicial review of this decision. This was the third one. In the last one, at the end of their video about giving some premium to the essential employees, and the question is it a premium as a compensatory measure, or is it a premium in order to encourage them not to strike? In Israel, in a bus company in the Negev, where they had in a collective agreement was a stipulation that the drivers will get some premium, extra money every month, but they'll not get it if they will be involved in a wildcat strike. And the question in a wildcat strike, not a regular strike, if a strike is approved by the Histadrut, is okay. Then they not get a premium. And the case came to the court. The Histadrut approved the strike, but didn't give a special notice. We have 15 days notice, the Supreme Court of Israel said that under the good faith requirement, they had to give an extra notice for the citizens of the city in order to know that the bus services will be cut this afternoon or something. And as a result, they lost the premium. So when they spoke about the premium, I didn't understand if it's a premium as a compensatory measures, as we speak about, and ILO speaks a lot about it, or it just as a way to assure compliance.
Just from my reading of the paper and the little I know, I did do some work in South Africa a long time ago, back in 1994 actually, and I followed things a little since. But the Essential Service Committee is part of a larger commission for conciliation, mediation and arbitration. So in the event that the matter is referred for interest arbitration, then it would be dealt with either by the commission or by an agreed arbitration panel by the parties, is what I would understand. But although the paper doesn't give precise statistics, they say there are a limited number of interest disputes referred, and one major interest arbitration that took place in 1999 and continued for 7 months and led to an inconclusive result. That suggests that there's not much taking place around arbitration at all. So it exists, you know, it's possible, but I think
Hardly invoked.
Hardly invoked, and maybe that's a majority union problem, that they don't see the need to do that. The premium, I think you could regard it cynically, and clearly there's a problem with wildcat strikes in around essential services and the delivery of essential services. So part of what they referred to in the video is, you know, the process of contracting out. So some people will not even be formally workers, they'll be independent contractors, and when they don't turn up for the job or they take forms of wildcat and formal strike action, that will affect essential services, but they're not really covered by any form of collective agreement or the general terms and conditions set within the bargaining councils. For those who are and are essential service workers, then the premium for them would be possibly as a deterrent for taking that kind of action, or it could be viewed less cynically as just because they're unable to bargain for an increment in their salary, this provides them with that additional protection. But to me, yeah, it seems to me like this covers, relatively speaking, so few of the workers who are genuinely working in essential services and the forms of privatization which have taken place in South Africa and elsewhere. So I find it, there's a formal network and it all looks like it works on paper, but I don't think it's working in practice.
We are recording it for them, so whatever you want to save, so it will help them to rewrite their paper. And if we want something to be clarified and so forth, it's very, very important, because we promised them to send them the recording of our session.
I mean, the one thing I would love to see in this is more of those issues that they raised in the video about the informal economy and how that works in practice, your law and action, seeping into their conclusions towards the end of the paper about the revision of the system. Maybe what we need is a greater protection of workers on the ground in other ways and guarantees of rights, rather than more formal tweaks to the essential services system.
So this is just based on what I've heard now, and mostly what I've heard from John now. I was wondering if maybe it would be helpful to elaborate on the relationship between the minority and the majority unions, and to understand on the ground actually what is happening and how that plays into this whole debate, as you suggested. So maybe some more contextualization going forward would be helpful.
It might be, yeah. And I know about the issue around minority unions in the context of the Marikana massacre, which was about a minority union coming forward in the context of mining. But I don't know about the extent to which that's a facet in the essential services context. I think there are
when we want to stay, this is the problem. We have, you know, this is one of, you know, there are a lot of problems, minority union, bargaining unit, a lot of things. And as we say yesterday, why we don't want to go into the problem of emergency situation, we want to speak about essential employees in a regular life of a nation. I don't think we should go into the minority issue, the minority union issue, because it's a huge issue. I know in the United States, in Europe, I think we want really to focus on this very issue. And I don't know how much in what you say, like freelancer or independent contractor or informal employment relationship in essential services. My guess is that it is rare. My guess, I don't know. And usually in most of the countries covered in this report, they speak about, they don't make any distinction now, at least, between public sector and private sector, because a lot of essential services now are provided by private sectors, and sometimes even by companies that provide just employees, like temporary health agencies. We had a big case in Israel of the people who protect the ministers, and it was outsourced by the internal intelligence to this contractor, and they went on strike, and it was a big issue, and it's covered in our case law. But I think the informal is less, I think, relevant. It's maybe there in the outside, but the question is.
You see, that's interesting, because in your context, agency workers are not informal. In the UK context, they're normally informal. They're not normally that well regulated. So it's a difference of context. So
no, but when it came in Israel, when it came to the court, the government wanted to issue injunction against them, and they say they work in the internal intelligence, and internal intelligence employees are not allowed to unionize and not to strike. And the court say to them, we're not going to issue injunction against them. If you want to employ them, then they'll not strike. But if you decide to subcontract this issue, they will allow to strike. We'll ask them to do minimum service, exception committee, but they will allow to strike. Clear and cut. No.
Well, you see, in the UK, there would be an issue as to whether agency workers are genuinely workers and therefore even have entitlement to strike.
Agency worker can
be not workers, yes.
Informal are very best in different countries.
No, we have even a law about agency workers, and no one really raised the issue whether they are workers. The only issue is who is their employer, but not whether they are workers or not. But this is the peculiarity of this very special and unique country.
Okay, I think we just now recently had a good example for something that could be considered informal. Juvenile delinquents that are sent to a type of prison. It's called a locked institution. It's not a prison, but it's called a locked institution, and it's by a judiciary decision they're sent there, and it was privatized to two nonprofit organizations, and it's supervised by the ministry, but everything is dealt by these nonprofit organizations who can inflict violence, and they receive special training to physically restrict children, and they are now in a labor dispute. It's a different organization. It's not Histadrut. It's a Power to the Worker, our radical friends, and it reached the courts because strike in such a service is dangerous to those juveniles, and same thing as with the minister's security. And if the ministry is not happy about it, then they should decide what to do with those workers. And the ministry announced that they want to nationalize it back into the state. And we don't know yet where is it going, but it's a very comforting decision.
Okay. We have to go. We are in a problem of time now, and they are going to close the university at 1:30. And so we are going to move now to Sweden. Birgitta, please.
Maybe I'll stand over there.
Please.
I think that would be the easiest for everyone.
Yes.
So cautious.
Yes. I do not. Well, Sweden, some figures. Trade unionism has traditionally been extremely high in Sweden, but as in other Western European countries, it has decreased during the last 20 years. Now it seems like it has stabilized at 70% of the workforce. 70%. If we go back to the 1980s, it was about 85%. And there are also, earlier, it was the traditional blue-collar trade unions that were very highly organized. Today, it's the public employees that are highly organized. The employers are also very well organized, over 80%, almost 85% of the employers. And this means that the coverage of collective agreements is 90% of the workforce. When we come to industrial action, there is, since the 1970s, a rule in the Swedish constitution saying that employers organizations and employees organizations, they have the right to take industrial action. This means that the right to industrial action is equal for employee side and employer side. Well, yesterday we talked about international standards, and I say that in Sweden, international standards are seen more like a confirmation of what has existed in Sweden for a very long time. It's the same with the constitution. It seems very late to have the right to strike in the constitution in the 1970s, but the constitution really takes a very minor importance in Sweden. As one of the trade union lawyers said to me, well, if I'm talking about fundamental rights and the constitution, well, then I'm really desperate. The right to strike according to the constitution can be restricted in legislation and in collective agreements. And we find very few, very minor restrictions in legislation, but we find a lot of restrictions in collective agreements. In legislation, we find the General Industrial Relations Act, which in Sweden is called the Co-Determination Act, which says that industrial action is for disputes of interests. You cannot use industrial action in disputes of rights. And during the lifetime of a collective agreement, there is a peace obligation. There is one exception from this peace obligation, and that is secondary action or sympathy action. If you, during the life of your collective agreement, you have the right to take sympathy action, secondary action, in order to support someone else. You could not say anything about your own collective agreement or your own employment relationship. You can support someone else. And that, of course, means that you can never be sure that there is an absolute peace obligation. The rights are equal for the employer side and the employee side, and the rights are almost also totally equal for private and public employees. For white-collar workers for blue-collar workers. There are, in the Public Employment Act, there are some very, very, very minor further restrictions for those employees that exercise public authority. If I'm a judge, for example, I'm not allowed to have partial strikes. I cannot say that I will make decision in all the criminal cases and not in the civil cases. I mean, that is for those persons, for those employees that exercise public authority. It would be seem very strange if someone representing the state could do such things, saying that, well, I take the criminal cases, but not the civil cases. So that is one minor restrictions for those exercising public authority. We've had discussions. Well, yesterday, Monica said or showed us that if there is a large room, legislation leaves large room for other actors on the labor market. That in Germany, it's filled by the courts. In Sweden, it's filled by the labor market parties. And we have 3 times during the history of labor relations in Sweden, we've had discussions about industrial action. First, it was in the late 20th century when collective agreements, trade unions, employers, organizations started to merge, and in the Swedish parliament they discussed, should we have arbitration in order to solve industrial action? That became never the case. Arbitration is almost never used in disputes of interests in Sweden. But these discussions in the parliament led to some developments. In 1906, there were some very clever, if I could say so, employers, very influential employers, saying that it's a silly thing to do to try and fight the unions. If we accept the unions, well, then we have someone we can negotiate with who is clever and responsible. So in 1906, the Employers Federation, the Private Employees Federation, and the Trade Union Confederation, they concluded an agreement where they accepted the organizations on both sides. And of course, this was most important for the trade unions.
That
the
was after a lockout?
Sorry?
That was after a lockout?
No, it wasn't. It was not after anything else. They just decided to that it was time to accept each other. And then the trade unions, they accepted the employer's prerogative. It's the employer who makes the decision about the work and about business. Also the same year, we got our first real labor legislation, and that was legislation about mediation. But the state did not want to, they saw the labor market as any other market. It was up to the parties to regulate. So this Mediation Act was very soft. If the parties both agreed, they could invite a mediator to help them in their negotiations. The second time where the question about industrial action was on the agenda was after the worldwide depression around 1930. There were a lot of unrest, industrial unrest in the Swedish labor market, and then the government and parliament, they appointed several governmental inquiries or commissions in order to find out how is negotiations made on the Swedish labor market? Is there any need for rules about action. What does it look like in other countries, etc., etc. Just like these types of commissions and inquiries do. And here, the labour market parties felt threat from the state. So in 1938, the Private Employers Federation and the Trade Union Confederation, they concluded the basic agreement, the so-called Saltsjöbaden Agreement. And here, they voluntarily make some restrictions in the right to take industrial action. For example, against the companies where only family members are employed, then it's not allowed to take industrial action. Also, in order to protect neutral third parties. But the most important of all was that they, in this Saltsjöbaden Agreement, they constructed the Labour Market Board. The Labour Market Board is composed of 3 representatives from the employer side and 3 representatives from the employee side. And if a party intends to take industrial action, which could threaten essential services, the other party could take that to the Labour Market Board, which then could, well, they are equal, they are 3 from each side, so it's more or less some kind of a negotiating committee. And also in the 1930s, the Act on Mediation was supplemented by a rule that you have to give notice of industrial action 7 days before to the other party and to the mediation office. So during this week, you give notice maybe of very wide industrial conflict, and then it's possible to take this notice to the Labour Market Board, discuss it there, or it's also possible to discuss it immediately with your counterpart and then try to limit these the announced actions. And that happens almost always, that notice acting is limited after discussing with the opposite party. Well, this Labour Market Board, it has only once actually found that notice action should be in an infringement of essential services, and that was in 1954. But the Saltsjöbaden Agreement and the Labour Market Board has become pattern for other parts of the Swedish labour market. Then, the third time when industrial action has been is in the 1980s. In 1965, public employees received the same rights when it comes to collective bargaining and collective agreement as other employees. So this state of things, that the same rules applies to everyone, to every employee, that has its origin in 1965. And then we had a very large conflict in 1980, the largest ever. We call it the general conflict. And all parts of the Swedish economy were affected. State employees, municipal, regional sector, and private sector. And well, the whole Sweden came to a standstill, actually. And there were also these boards in the Labour Market Board for the private sector, but also this patterned boards for the state sector and the regional municipal sector. Actually, in 1965, when the legislation gave the state and municipal and regional employees the full rights to collective bargaining and collective action, it was they actually had to do something similar to the Labour Market Board and the Saltsjöbaden Agreement, and they did that. Okay. Then in the 1980s, after this large conflict, almost every wage round, there were large conflicts in the public sector. And people started to discuss that maybe the public employees and the public employers, because the public employers, they answered with very large lockouts. So maybe they were not responsible enough to have those full rights. So the state did the same thing as in the 1930s. Well, we appoint a commission or an inquiry. Let's see what has happened with industrial conflict and collective bargaining during the recent years, etc., etc. And also this time, the parties felt threatened, and this led to three things. The boards that should assess essential services in the public sector, the state sector and the municipal sector, they added impartial members of these boards. That was the first thing. The old mediation system from 1906, we had a new mediation system from 2000, with lots more of resources and also a little bit more powers. And the third thing was that the labor market parties in the industry sector, they concluded what has been called as a secondary Saltsjöbaden agreement. It's called the industry agreement, where they have arrangements to avoid conflicts. They have even a private mediation system, which means that the state mediation system do not apply to them. And this industry agreement has also become a pattern agreement for the rest of the Swedish labor market. So how do we deal with essential services? Well, after this notification 7 days before, well, the parties negotiate, and they very often find out that we should limit the announced actions. And also, in many cases, the parties from the beginning gives exemptions for essential services. Also, according to the basic collective agreements, they agree in these agreements that, for example, health care and so on, they should be especially cautious there. Mediators, they usually ask the parties to postpone announced actions, and in most cases, the labor market parties do that. And also, we have those boards that should assess essential services, but they very, very, very rarely do anything. One of the negotiators for the employers said to me when I asked him about it, well, the boards, they can only be used because we know that they are there. We do not want to use them, but the knowledge that they are there, that stops us from strikes or lockouts in essential services. So finally, since that industry agreement was concluded in 1997, we've had very few conflicts in Sweden altogether. We've had, during the last 10, 15 years, we've had a few conflicts in the municipal regional sector. Nurses, doctors, dentists, and sometimes there has been discussions about essential services, but there has not been any decisions in the boards. This has solved itself because the parties, they give exemptions from their notice strikes. One example I would like to mention is in 1990. 1,500 bank employees went on strike. The banks in Sweden are private. The employer answered by locking out 45,000 employees. There were strikes and lockouts for 3 weeks. The banking system came to a total standstill in Sweden, and mediation lasted for 3 weeks. The mediators, they succeeded in solving the conflict, and the banking sector is outside the large sectors, so they do not have any board for essential services. So this was just an example. Thank you.
Monica?
Okay, so what we have heard here was kind of model for a system based on self-regulation by labor market parties. And in a sense, what we have seen is that it is not necessarily bargaining in the shadow of the law. It can also be bargaining in the shadow of the threat of there coming a law. So this is something that is relatively unique when compared to what we have heard before. But on the other hand, it obviously functions quite efficiently. And it has been explained very vividly. So the only thing that I would perhaps ask for is not structuring it so much along the historical way, but much rather along those types of boards and types of mediation that could potentially end the industrial conflict. Because for me, it was from time to time difficult to realize, now there are private and there are public mediation boards, and how is their relationship towards each other? Who is responsible for what, or would have been responsible? If I understood it correctly, they are not really used that much. And so this looking at it from the perspective of the organization would make it easier for an outsider to understand how things work. And then the role of mediators as such, they are chosen by the parties, and this is the case as long as things work. They can do it on the private basis, on their own basis. Only if it would not work, then the public mediation, no. So then that is something that needs to come out a bit more in detail from my perspective. What I found very interesting was that there is a rule that negotiations should be completed before the previous agreement expires. That is
the
what,
industry agreement.
yeah, that is what you told us. And I mean, this is a very efficient, once you have a peace obligation in your system, that is a very effective way of avoiding industrial conflict altogether, because then the next peace obligation would immediately follow the first one, no problems whatsoever. And another aspect that to me was that the level of bargaining is the central level, much rather than the lower level. So if I understood it correctly, this was in practice because it is the central level who has the money.
Yeah.
And that would then mean that obviously someone has to help striking workers, and that would be paid out of this money that the central level has.
Yes.
And then that, of course, is also maybe a method of avoiding competing unions on the ground. If it is only the central level that decides, then of course, are there any competing unions at the lower levels? It doesn't seem to be the case, but how is that you do not have such a thing? One additional information that was very interesting to me was that the refusal of an employer to contract with an applicant that is a member of the union is not a violation of those rights, because protected are workers and not applicants. That's of interest. That is not the case everywhere. So maybe important to know. What we then find is that an illicit aim or purpose makes a strike illegal. And one of that illegal aims would be to overcome an already existing collective agreement of another union. So this is very interesting. So if there are two different unions responsible for the same problem, then all they can do is that they ask for a parallel collective agreement and not a competing one. That would probably mean that they have to have the identical content. No, no. Okay, so then that would also be a question that I have. Then you told us mediators have the power to postpone collective action, and that would then mean that those mediators, they would need more time in order to find a solution. And what will happen during this period? Will then the terms and conditions of the old collective agreement continue to apply?
Yes.
Okay. So that is then just simply a technical way of extending the time period of the collective agreement.
Giving the mediators
Yeah.
more time to work, but that has only been used 5 times.
Yeah.
Only 5 times?
Yes, but the possibility we have had the possibility since 2001, and it has been used 5 times.
It's not their decision. They ask the parties, please give us more time.
No, it's the board of the mediation office. So we decide there in the board of the mediation office, we are 3.
So sometimes they decide against the will of the parties or one of the parties?
Oh yes. That is the whole point. Because otherwise, if it was the will of the parties, well then they would themselves postpone these strikes or lockouts.
And then finally, what we have is that in principle, it is the responsibility of the parties to secure third parties' interests, like the one that are vital for essential services. So the labor market parties would take that into account themselves by, for example, restricting their initially announced amount of scope of industrial action. But if this is not the case, then the state may intervene by legislation. And you also said that this doesn't happen.
That has happened once, in 1971, when judges, teachers, it was all academic workers that were on strike. And I think this was more or less a political decision, because that time we've had for many, many years social democratic governments, and then suddenly the academics, the privileged, they go on strike, and then there was a legislation which the government posed to the parliament, and the parliament accepted it, and the legislation said that the former collective agreement will be valid for another 3 months, and there the conflict was solved. But that was more or less, I think, a political demonstration. Privileged people should not take industrial action.
Okay, so that actually, as I initially said, that is very impressive, that there are several potentially far-reaching instruments, but the fact that they are there, that is enough. They need not be used. Because
in
then,
Sweden.
In Sweden, yeah. Well, of course, everything is working under the conditions of this respective system. But in that case, that was very impressive, because then self-organization, obviously,
And I think it is extremely important here. I have a colleague who says that the labor market parties in Sweden, they are in a compulsory marriage without the possibility to divorce. And also he used to say that this is our boat land. Please sit still in our boat, because if you move too much, we'll both get wet. So I think that is a good description. But if I may answer your question, the private mediation, that was something very complicated, because the government had a state inquiry in the 1990s, and I was an expert in that inquiry, and we were supposed to propose new legislation about mediation. And then, during the time that inquiries in the industry sector, they concluded the industry agreement. And what did we find there? That the parties themselves had invented a new kind of mediation with their own mediators. And in a system where you say it's the parties that should do the regulation, not the legislature, well, then we had to say that the legislation which we propose, that if they have private mediators, they can use the private mediators, and the state mediators, they are not competent in that area. So if they have in their, I think today it has been 60% of the labor market that have had this private arrangement, but I think today it's only 40%. But then use their private mediators, and they find, thank you, that they cannot succeed. Then they can turn to the state mediation office and ask them for public mediators. So, and also this competing union. Oh, that is a really, at the moment, we've had for almost half a year, I think, we've had a strike in the harbor of Gothenburg. Gothenburg is the second the town in Sweden, and it's the largest harbor in Sweden. But they have almost closed the Gothenburg harbor, and actually we do not know how to solve this dispute, because the harbor has a collective agreement with the Transport Workers Union, which is a large union, and then there is the Harbor Working Union, which is one of those specialized unions that actually they like to make things complicated. And if I understand it rightly, and if the State Mediation Office understands it rightly, the Harbor Workers Union, they more or less want to take over the harbor. They know how to conduct the work and to make the employer prerogative decisions. So this is almost impossible to solve, because they don't want this parallel collective agreement. They want a collective agreement of their own, and that is not. You can ask an employer who already has a collective agreement for this kind of work, would you like to conclude a secondary collective agreement? It would be a very silly employer, because then he would be in breach of one of the collective agreements, but it happens. And you can have them parallel, but if you ask the employer to conclude a second collective agreement for the same work, and you say, but then you cannot apply the first one, I want to push the first one away. That is illegal. That is illegal aim.
So is it going on still, the dispute?
In Gothenburg Harbor, yes it is.
And is it similar to what Monica spoke yesterday about the niche unions in a way in Germany?
In a way, it's similar to that, yes.
Mm-hmm.
So if they could push it away by making a request that in their collective agreement, there would be inserted a clause saying that the employer is disallowed from applying the first one.
And that is illegal. That is an illegal aim which makes any collective action in order to get this second collective agreement.
But that would then mean that it would be possible to have an agreement which is a contract to the detriment of a party that is not involved. I mean, under contract law, that is a very strange thing. It would be legally possible, even though it is an illicit aim for a strike.
But that secondary collective agreement will not be applied.
Yeah, okay. I see.
because it has an illegal aim.
I see. But
I
that-
mean, this question appeared when we have those ships with flags from Cyprus, etc., and then they wanted an international Siemens collective agreement, or even a Swedish transport collective agreement, and then there suddenly the ship said, well, we are under Cyprus law and we have a collective, Cypriotic collective. So that is the origin of these strange rules.
it might be nice to explain that.
Yes, yes.
Because that was
Yes, it's
really
very
strange.
strange.
It was very strange.
Can I just jump in with a broader question? Because, in describing this regime, you say it's based on this deep-rooted trust going back to the beginning of the 20th century. What is so remarkable for me in listening to this is that from that, you think about, okay, so you had this history, but there's been such massive historical breaks, right, with social democratic governments losing power or effectively accepting neoliberal agendas and austerity measures. And in Sweden, as I understand, capital, which used to be entirely national, has become much more internationalized, which usually, sort of leads to a breakage in these narrowly constructed national arrangements. So how is it, right? Is there something in your paper that describes the exceptionalism of the survival of this exceptional model in an era in which these kinds of arrangements have largely been swept away by the forces of neoliberal globalization? I mean, that's just that's what is really remarkable to me listening to your story.
Well, maybe not enough, but of course, the decline in trade union membership is something. Now it seems like it has stabilized, but we were very worried during about 10, 15 years that it would continue to decrease. And that is something. And also, as you said, international competition and EU law, the Laval case, which always seems to end up any Swedish discussions. But that is still only very minor things.
We heard yesterday from Eric that in Canada they use the ad hoc legislation during the strike. Did I hear you right that you said that you used it once? Because I know that either Norway or Denmark used it several times,
Yes.
and they went Norway and they went to the ILO. There was a complaint in the ILO for using the ad hoc legislation, again extending the collective agreement in order to avert the strike.
Yes.
Okay.
Denmark and Norway have a slightly other tradition than Sweden here. We are rather similar, but if you look upon it more closely, we are not similar at all, and that is the difference. And I think that origins in the fact that both Norway and Denmark were occupied by Germans during the Second World War. Then they started by this intervention from the government.
Which is something that unheard of probably in Germany, but it's still under the German tradition. You explained that this is why Norway and Denmark will do it, and in Sweden not.
Maybe.
Yeah.
Well, it's not a comment on your paper, but it just a problem I realized. I was thinking about. Realized now when you were talking about the shipping company under a flag, a different flag. Something we haven't, it seems to me, discussed, but very relevant in the essential services sector, is the fact that, especially in the transport sector, a given jurisdiction is not always able to deal with a strike in the sector whenever the company has a different flag. And this is very true about the air transport. If we think about strikes in France of flight controllers services, they stop Europe from having transport, the Lufthansa transport, the strike of the pilots that stopped all flights and connection wherever in Europe. The same, the fact that, for example, you may have disruption in Italy when EasyJet doesn't work, or Ryanair, but Ryanair is under the Irish jurisdiction, or the employees, they work under the Irish contract. Situation of connection between services, especially in the transport sector, that a system is not able to deal with, because there is fragmentation on the side of entrepreneurship, the companies. So the Italian authority is not able to discuss with the head of the service that is Ryanair in Ireland. Okay, so they are the dispute with pilots. Pilots are hired by an Irish company because they are flying. Okay, they are not based